The engineers are prodding the hamsters on the wheels as we speak.
When I was in, before we get to Aaron here, we appreciate him coming in, Aaron Rice, but when I was in, just briefly, when I was in Columbia last week doing the show, had a regular listener text in that said he was listening on the app while riding the Skyliner at Disney and was commenting on how powerful the network signal is there, the Wi-Fi signal, which powered his app. So we appreciate that. But joining us now, of course, our good friend Aaron Rice, the director of the Mississippi Justice Institute. We appreciate you coming in today, Aaron.
Yeah, thanks for having me, Gerard.
Couple of things we wanted to chat with you about, sir. First of all, the Biden vaccine mandates, which appear to me to be going down in flames.
Yeah.
Really, if I could set the stage here, three major aspects of that, best I can tell. There's one that would require healthcare workers that are employed by healthcare institutions that participate in Medicare and Medicaid. That would be from the CMS.
Yeah.
That one has been challenged. Looks like that's been struck down, at least in one of the courts. And then you got the other one, which requires federal contractors to be vaccinated, employees of federal contractors. Looks like that went down. And then finally, the component which would require private employers with more than 100 employees to vaccinate all their employees. That one seems to me, honestly, to be the most egregious and the most overstep. Looks like, and so we had this lottery, which I didn't even know about, to determine which one of the federal courts would hear all these cases going forward. The lottery landed in the Sixth Circuit, I believe, which is primarily Republican judges. I also learned that there is a bench of judges that are picked sort of randomly, actually by a computer,
panel.
A panel.
Yeah.
So it's not like it's just this many judges and they all sit there and they hear all these cases. They kind of rotate that around.
That's right. And we're arguing, and I say we're because, the Mississippi Justice Institute has one of these cases in the private employer mandate that you talked about. So in that's the one where there's the lottery with the judicial panel on multi-district litigation has consolidated all this in the Sixth Circuit. And so leading up to that, and I guess I'll just start with the private employer mandate, we filed suit. I said several states, including the state of Mississippi, and private employers in those states, including private employers here in Mississippi. We all filed suit in the Fifth Circuit, and the Fifth Circuit very quickly issued a stay and said, that OSHA could not move forward with that mandate. The federal government, argued for it to reverse course on that. It reaffirmed it in a lengthy opinion and said, no, we're sticking with this. We're having this stay. Then all the cases around the country got consolidated into the Sixth Circuit, and that's where we are now. Is the Sixth Circuit gave everybody some time to file motions to either extend that stay that the Fifth Circuit had issued or modify it or get rid of it, and everybody's been briefing that. And so the court is going to decide soon. Now, the other thing that we're arguing for in that case, you mentioned the panel. It is normally a three-judge panel will decide, and then you can appeal from there. If you're the loser, you can say, we think the entire court, the Sixth Circuit, which is 20-something judges, should hear this, and they may or may not grant that. If they don't, then you can appeal to the Supreme Court, who may or may not take it. We're asking for the entire Sixth Circuit, not a panel, to hear this from the get-go. So, but right now, the court is deciding whether to do this as a panel or whether to do it as the entire court. And they're really deciding, too, whether to keep this stay that the Fifth Circuit issued. And then after that, they'll be deciding on the merits of the case. Are we right? Is this unconstitutional? And does it violate other statutes or not? And then, it could go up to the Supreme Court pretty quickly after that.
Okay. So, wow. It's complicated.
Yeah, it is.
At a minimum, it is. But, you could argue that it's complicated because you had a government that really tested the extent of its authority here.
Yeah, it's that's been an interesting thing to me to watch. Is I've heard people in general comment on how it seems like we're litigating everything these days and everything goes up to the Supreme Court, and that's true for some other reasons. There's some other things that drive that, but one of the things that seems to me to drive it is just that elected officials are willing to push the boundaries a lot more than I think prior generations of elected officials were, and there was kind of an understanding in prior times of here's what the Constitution says, here's how our country operates, and I'll be honest, you see it on the right sometimes too.
Sure.
But people are willing to push a lot further now, and a lot of that needs to go to the courts to resolve, hey, is this going beyond the constitutional limits of the government or not?
You got to believe that a great deal for that kind of borderline abuse is that we just have divided government in the Congress. Can't get anything done.
Yeah, that's right. And I think, we've all seen it. I mean, the attitude in American politics where things are so divisive. I mean, not just divided government, but culturally we're divided and all of that. We know that, gridlocked. And so I think over time that's pushed elected officials to be willing to just go further with their with these laws that they want to pass, sometimes almost symbolic, just to say, we're going to get you.
Yeah.
We're going to make a boogeyman out of the other side, even if they know that it might get struck down. I mean, I'm convinced that the Biden administration was pretty confident that, especially this OSHA vaccine mandate, the one that applies to private employers, I'm fairly convinced that they knew that would get struck down. And so that's, again, an interesting thing. I think you and I have talked about it before, though. Mm-hmm. I think they were wanting to get caught trying, as you would call it. Like, they knew they couldn't really do this, but they thought at least some segment of their base really wanted them to, and so they were willing to just do it, knowing it'd get struck down, just to get caught trying.
Yeah. Even indicated as much, did they not? They were trying to figure out a way to circumvent the Constitution.
That's right. I mean, there were tweets about that, and they had kind of said in the past, OSHA had said previously that we do not have the constitutional authority to do that. And then after President Biden comes out and says he's getting impatient with unvaccinated workers or people in general, they reversed course and said, actually, we can do this.
Oh, jeez. All right, so I'll extend that question then about the legality of these sorts of mandates. You may have heard this morning that New York Mayor Bill de Blasio is instituting a private sector vaccine mandate within the city of New York.
Yeah.
So just in general, does a mayor have that kind of authority?
Yeah, and I actually, when I was coming into the green room, I heard you mentioning it, and that's the first I had heard of it, so I really don't know the details on that. But a mayor actually would, in terms of, now these are totally different questions on whether this is a good policy or whether there's some state law that would override it. But in terms of the constitutional issues we're talking about in the litigation we're involved in, a city official would have a lot more authority to do this, actually, than the federal government would. Because you got to remember, and people forget this, but the federal government was designed by the founders to be a limited government that only had specific enumerated powers.
Right.
And then you've got issues with separation of powers. So, for example, even if the federal government could do this, the vaccine mandate, then you could argue that, and I would argue that really Congress should be the one that would do that, not an agency, an executive agency. So you have all those issues. But when you're talking about a city official, a lot of those issues go away, and you've got more of a local official who's got just kind of more plenary authority to do things to protect the health and safety of his citizens.
But that, of course, would not preclude a business that is impacted by this from filing a lawsuit.
No, they can file a lawsuit, and there may be, there may be issues under New York law.
Yeah.
And that's why I said the federal Constitution might not prohibit this, but the New York state Constitution might prohibit it, or state law in New York might prohibit it.
That makes total sense. All right, so what's the status of your client's case right now?
Yeah, well, not a lot has changed since last time we were in here, because like you said, it got consolidated into the Sixth Circuit, and so that kind of paused everything, and we're now relitigating what we already litigated the first time with the Fifth Circuit, which was just trying to get the stay. So the Sixth Circuit has not decided yet. The briefing just finished on that last week, and so we're waiting to hear from the Sixth Circuit on whether they're going to keep the stay that the Fifth Circuit put in place. Hopefully they will. They're obviously also having to decide whether they're going to hear this as just a panel or the full court, and all kind of things are going into it. And it's a lot of parties now that we've gotten consolidated. It's a lot of moving parts. There's papers are getting filed. Dozens of papers are getting filed every day. It's hard to just even keep up with what's going on. So yeah, I'm not sure exactly when the Sixth Circuit is going to come down and decide on that, but we're waiting to hear on that. But the case is going to continue moving forward.
Man, my business hat here says we got enough to deal with besides this.
Yeah.
I just can't imagine as a business manager having to also deal with this situation.
And that's one of the reasons we're really glad we got the stay from the Fifth Circuit, because none of the other circuit courts issued a stay that quickly. So I'm glad that in our case that was pending in the Fifth Circuit did that before we even got consolidated, because if they hadn't, the Biden administration would still be pressing this and moving forward. And right now we're at least on a hold.
Aaron Rice is our guest. We're glad you're here, Aaron. When we come back, we're going to talk about this big-time abortion case.
Yep, great.
Stay with us. Middays will return. We should, of course, congratulate Coach Deion Primetime Sanders and Jackson State University for winning the SWAC championship. That's a big deal. Congratulations to them. We've got Aaron Rice in the studio with the Mississippi Justice Institute. All right, let's pivot, Aaron. Let's talk about this abortion case, which is front and center. And Mississippi clearly in the spotlight on this deal because there are gazillions of reports and articles and, of course, media discussion, and it's always the Mississippi abortion case.
Yeah,
that's
that's
how
right.
it is referred to, the Dobbs versus Jackson Women's Health Organization. How do you think it went last week?
I thought it went really well. So I went into it. I think there's probably just a lot of attorneys who are, and just not non-attorneys as well, just pro-life folks who have had decades of kind of seeing Roe v. Wade be just immovable, and everybody thought the Casey decision was the chance to get rid of it, and it didn't, and
Right.
all of that, and so are just very pessimistic on anything really changing, even when you have a new court. But I went into it not too hopeful and thinking that the court might want to find a way to just tinker around the edges or kind of move the line a little bit, kind of find a third way, middle path type situation. I came out of watching the argument thinking that is not the case whatsoever. And of course, you can never predict, or it's dangerous to read the tea leaves. But I've never seen an oral argument where the justices seem to show their hands, show their cards as much as we saw here. And based on what we saw in that oral argument, it seemed very clear to me that you have 5 justices who want to overrule Roe and Casey. And so I felt very good about it coming out.
Yeah. So I did as well. And the thing that struck me, Aaron, is that within 24 hours, all the various media that I viewed and read and reports on it from the left side of the aisle, media, which is most of the media, they seem to be resigned to the fact that there's going to be some change.
Yeah.
And actually we're somewhat tenuously complimentary of the state of Mississippi and the arguments from our Solicitor General.
Yeah.
And felt like that for the most part it went well. For the pro-life movement and didn't go well for the pro-choice.
Yeah, I think it was just, it's hard to watch that oral argument and come away with any different opinion than that. You know, I mean, you had, Breyer and Kagan and Sotomayor, valiantly trying to, make whatever the arguments they could, but they were clearly on an island by themselves. And then you had Roberts kind of doing his own thing, completely trying to continue pushing, hey, why don't we just get rid of viability and keep undue burden, kind of keep, this middle path, like I said. But he had no buyers from anybody, either on the left or the right. I mean, nobody was really interested in what he was doing. And in fact, none of the parties were interested in that. I think it was, who was it? It was Gorsuch maybe that pointed that out to Roberts during the argument and just said, he asked the Solicitor General, I think, would this work? Would some third path work where we got rid of viability and tried anything else? And everybody he asked that to said, no, there's really no other way to do this. And so, you watch that, I think it's just pretty clear that you're either going to overturn Roe and Casey, or you're not. And there's ways where, the court could come up with some split decision that basically upheld the Mississippi law, but didn't overturn Roe v. Wade, and there wasn't no 5 justices agreed on anything other than upholding the law. And so then you'd just be in kind of a no man's land where it's like, until this gets up to the Supreme Court again, we really don't know what the law is, other than that the 15-week ban is upheld. But I don't think that's what we're going to see.
Yeah, I think you're right. One of the best analysis and most thorough analysis that I found was from the Kaiser Family Foundation, which, of course, is a healthcare policy think tank. And they kind of mapped out 3 different scenarios: a complete reversal, repeal, strike down the law, and then something that's sort of in the middle, maybe changing the standards set by the Casey case with respect to viability, and then upholding Roe v. Wade. Kind of the 3 paths that they saw were in the future, and of course it's expected to come down in June, July. What
that's right, June. And that's what I think too. Is like I said, I went into it thinking you'd see more of that middle path. I mean, I didn't think, it takes 4 justices on the Supreme Court to even take a case, and so, knowing that 4 justices had voted to take it, it seemed to me pretty clear that the court wanted to do something here. It wouldn't make sense that they were going to take this case and then just, strike down the Mississippi law and uphold Roe and Casey. I didn't think that was going to happen. But I also didn't want to get too optimistic. And part of that is because we just don't know with a lot of the new justices. I mean, Gorsuch has never really talked about abortion. I've seen him in some opinions kind of make fun of the penumbras of rights, and that's kind of a hit on the Roe decision, and some cases preceding it. But But he's really never had to deal with abortion. It's hard to know where he was. And then Kavanaugh and Amy Coney Barrett are both institutionalists like Chief Justice Roberts. And, we can talk about what that means if you want. But, they're just not really going to rock the boat most of the time. And so, it was hard to know where's Gorsuch, where's Kavanaugh, where's Amy Coney Barrett. I thought Gorsuch would be with Thomas and Alito to overrule. He clearly was right out of the gate. But I wasn't really sure about Kavanaugh and Amy Coney Barrett, and became very clear Kavanaugh is a definite. Yeah. I think he was one of the 4 that voted to take the case. I mean, he was very strong throughout the oral argument, and he kept, when some of the liberal justices were talking about stare decisis and how you basically can never overrule anything. Right. I mean, it was so absurd, and Kavanaugh pointed that out. And I'm not saying that stare decisis is not a thing. It clearly is. I mean, that's a rule that the court kind of imposed on itself that says let the decision stand unless there's some really good reasons here, and there's a whole way you analyze that. But it's interesting to me because these liberal justices and liberal court watchers who now are acting so aghast that, we can't, there'll be this stench, if we overrule a decision. It's terrible. We can't do that. And it's just a one-way street with them, it seems like, because, if you just look at, for example, the Obergefell decision that wasn't long ago that was on, marriage equality. I mean, that overruled precedent with hardly any discussion about why. It was just, this case is overruled. Mm-hmm. We're not going to let this stand anymore. And then if you look at the Warren Court for decades, that just kind of glibly overruled precedent and came up with things like Miranda rights that we're all familiar with now and all kind of things. And so they never really cry foul when I think what it is that they view it as there's this kind of cultural march that is supposed to be happening in their direction. And so if you're overruling precedent that's kind of this old bigoted, cases, that's fine. But if once, something that is kind of a progressive, agenda item is enshrined into Supreme Court precedent, that's untouchable. You can never come back and overrule that. That seems to be their mentality. And so, but my point on it was that Kavanaugh really went after that and showed how ridiculous it is, pointing out Plessy versus Ferguson, how wrong that decision was, and Brown v. Board, fixed that, and all the times that the Supreme Court has overruled clearly wrong precedent. And so, anyway, seeing where he was and then really seeing where Amy Coney Barrett was as well, she seemed, she showed her cards the least, I think, but the questions she asked seemed to clearly be indicating that she thought Roe and Casey needed to go as well.
And, of course, there are a series of Democrat lawmakers who have renewed the calls for expanding the court. You knew this was going to happen. We don't get the decision we want, so let's just add to pack the court so we can get everything we want our way.
Yeah, so, that's right. That's right. And I think we'll see that, if June comes around and Roe and Casey are overruled, I think we'll see, renewed calls to pack the court. I was grateful to see that the Biden administration kind of the committee that was put together to look into Supreme Court reform pretty thoroughly shot down the idea of packing the court, which I was very relieved to see that. Of course, this was not in an election year, not in a presidential election year, so you never know what would happen, in future election years when that issue may get raised again. But so for now, I feel like, the court is safe. But you're right. I mean, when a decision like this comes out, it could, alter that dynamic. And that's really what those threats are about, is those threats to pack the court were intended to intimidate the U.S. Supreme Court from doing what it is poised to do right now.
But they are they're tasked with just ignoring all that nonsense. They just got to rule in accordance with the law.
Yeah, and that's what they're supposed to do. Yeah. I mean, there are documented instances. I mean, even in Roe, Casey, Justice Kennedy changed his vote, and it's pretty well documented that Casey would have gotten rid of Roe, except that initially in conference, Kennedy was on the side to overrule, and later changed his mind basically based on kind of constitutional scholars on the left who were kind of working behind the scenes to convince him that it would ruin his legacy if he didn't. So, judges are people too, and sometimes, the pressure can get to them as well.
Wow. Aaron, appreciate you coming in. Yep. Your insight is always appreciated and valuable. Thank you, sir.
Enjoy coming on. Thanks for having me, Gerard.
You got it. Aaron Rice, director of the Mississippi Justice Institute, has been our guest. We'll take a break here and come back with more Middays. Stay with it.